Hi, in this presentation, we will discuss about patent application types and where and when to file patent application. We'll also discuss about various routes through which you can file patent application. So let us first discuss about type of patent applications. First is provisional application, which is a summary application. So when you have not completed or perfected your invention, you can file provisional application as summary application in order to get the priority dates. So when you file provisional application, you will get the priority date. The date will be the priority date. And after filing provisional application, you get 12 months to perfect your invention, to complete your invention. So within 12 months of provisional filing date, you can file complete application. So provisional application is a summary application and which is not even required to have claim. You need not to add claim in the provisional application. And provisional application is not examined. It only establishes priority date. Next is original or parent complete application. So when you file the complete application after perfecting or completing your invention, that application will be complete application. So you have to file the complete application within 12 months from priority date or within 12 months of filing of provisional application. Next is continuation application, which is a continuation of earlier filed or parent application. So suppose in original or parent application, the applicant has claimed very broadly, maybe claiming structure which is including 4 products. Now patentee want to narrow down his claim to maybe to one product only. So in that case, you can file continuation application. And in continuation application, you will claim narrowly only maybe only one product. Next is continuation in part or CIP application, which is application which is partly continuation of parent or original or earlier filed application and partly having new material. So in this case also, suppose original application is very broad. Now patentee want to claim maybe not broadly all 4 product, maybe you want to claim only one product. So he will file CIP. So through CIP he will claim narrowly. He will having partly the material of original or earlier filed application and partly you will be having new material. So in this example, suppose you want to claim narrowly only one product, so and he want to modify that product also. So in order to modify that product which he has claimed from original parent application, he will add new material. So that new material will modify the product. So that's why this application is called CIP, because partly it is having material of parent or original application and partly it is having new material. So that's why it is called CIP or continuation in part. Partly it is continuation of earlier application, partly it is with new material. Next is divisional application. So divisional application is divisional of parent or earlier filed application. In divisional application also, suppose earlier original application patentee or applicant has claimed 2 products in one application only. So now he want to claim these 2 products separately in separate application. So in order to do that, he can file divisional application. So that second application will be called divisional application, which is claiming each product separately. Next is PCT application. So PCT application is an arrangement by WIPO, World Intellectual Property Organization, which is part of UN or United Nations. So before PCT, what was happening? Suppose there is no PCT, what will happen? The patentee want to file patent as soon as possible. So if patentee wants to file application in many countries, so what will he be doing? He need to file patent application in all those countries on the same day. It is very difficult. You cannot file all application maybe in more than 150 country on the same day. It is very expensive, resource consuming. So it is very difficult. You cannot file all application on the same day. So in order to solve this problem, the WIPO came up with the solution with PCT application. So the PCT application is through Patent Cooperation Treaty. So this is treaty which is signed by more than 150 countries. So through this treaty or PCT, applicant can file a PCT application in his home country. So you file application in your home country. Now applicant get 30 months to file application abroad. So he need not to run on the same day to file application abroad in all countries. So this solution is provided by WIPO. You file application in your home country, you get 30 months. So in 30 months you can file application abroad. So that is PCT application. Next is national phase application of PCT. When you file the national phase application of PCT in each country, that will be national phase of PCT application. Now requirements for filing continuing application. In general, the continuation, divisional and CIP or continuation in part, they are all called continuation application. So the requirement for filing continuation application are: first, there must be one common inventor in the original or earlier filed application and in the continuation application. One inventor should be common. If there is no common inventor, then you cannot file continuation application. Next requirement is chain of codependency should be maintained at time of filing continuation application, which means when you are filing continuation application, at that time the original or parent or earlier filed application should be pending. Patent should not have been granted on that earlier or original filed application. If patent has been granted on that application, then co-pendency is not there. So you cannot file continuation application in that case. So if chain of co-pendency is lost, then priority of the invention of your continuing application is also lost. So priority of invention is lost when the co-pendency is broken. The parent or related application may be prior art if chain of co-pendency is broken. If this chain of co-pendency is broken, then earlier filed application, the original or parent or earlier filed application on the basis of which you are filing continuing application will act as a prior art for your continuous application. So these are the requirements for filing continuing applications. Now the relevant dates for the patent applications. First is priority date. It is the date when you file the provisional application. Next is filing date. When you file the complete application, that will be filing date. PCT filing date will be date when you will file complete PCT application. National phase filing date of PCT when you file national phase application of PCT in each country. Next is publication date. When your application is published, that will be called publication date. And each application will be compulsorily published 18 months after priority date or earliest filing date. So every application will be published by patent office after 18 months from priority date or earliest filing date. But applicant can request for earlier publication also. If applicant wants to publish his application earlier than 18 months, then he can file a request for early publication. Prior to publication of application, the application is kept confidential by patent office. Next is date of grant. It is the date when patent is granted. In this slide, you see the original patent, first page with bibliographic information and various dates, relevant dates for a patent application. So on the top, you will see the date of patent, which is grant date. Then in the end, you will find provisional application number and provisional application filing date in 2004. Then you will see the application number, the application filing date in 2010, and this 2005 10 filed application is a division application from earlier filed application in 2005. And then you see the publication date also in 2011. So all these dates are given on the first page of patent document. Now coming to where and when to file patent application. Now where to file patent application? It is company or patentee has to decide where he wants to file the patent application. He will decide on basis of which he will decide what invention he is having, what is the market for that invention, in which country invention is having the market. So based on where the market is, in which country the market is, the patentee or company will decide where they want to file the patent application. So in countries which you want to protect your invention, you will file patent application in those countries. Now various routes of filing patent application. There are basically three routes: direct route, Paris Convention route, and PCT route. Direct route. Coming to direct route, you can directly file separate patent application in each country, but at the same time you have to file all the application on the same date. It is very important. You should file all the application on the same date, and it is very difficult to file all application in all country on the same date. So it is not possible to do that. It is expensive, time consuming, resource consuming. So this direct route is very difficult. So if you want to file application abroad in many countries, then it is very difficult to take the direct route. So in order to solve this problem, there are two other routes. One is Paris Convention route and next is PCT route. Now let us first discuss Paris Convention route. There was a convention called Paris Convention for protection of industrial property. This convention happened in 1883. Through this convention, it provides the right of priority in case of patents. So if your country is member of this convention and India is member of this convention, then you can file a priority application or an application in your home country. After filing application in the home country, you get 12 months. You can file application abroad within 12 months of filing application in your home country. So you first file your application in your home country, local patent office, then within 12 months you file separate patent application in other countries within 12 months. So you get 12 months. So in direct route you are not getting any time. In direct route you have to file all application on the same day, which is very difficult. In Paris Convention route you get 12 months. You can file application abroad in 12 months, not on the same day. Now coming to PCT route. PCT route you provides you with 30 months instead of 12 months in the Paris Convention. So you file your initial priority application or initial application in your home country, then you get 30 months to file application abroad in other countries. So PCT route is providing you more time for filing application abroad. So PCT application you can file directly in your home country, or maybe you can file within 12 months of priority application. First you file priority application, then within 12 months you can file complete PCT application. That too you can file the complete PCT application also you can file in your home country, not abroad first. First file priority application in your home country, then within 12 months you file PCT application, that also again in your home country. So from priority date you get 30 months to file application abroad. So your PCT route gives you 30 months. Paris Convention route gives you 12 months to file application abroad. Direct route is not giving any time. In direct route you have to file all application on the same day. So these are the three routes for filing patent application: through direct route, through Paris Convention route, through PCT route. And Paris Convention, it happened in 1883. India became member of Paris Convention in 1998. US is member of Paris Convention from 1887. Similarly, India is member of PCT from 1998 and US is member of PCT from 1978. PCT was concluded in 1970 and US became member of this treaty in 78 and India became member in 98. So this slide shows you the two routes, Paris Convention route and PCT route. So you can see in this slide, very easy explanation. At time 0 you file local application, and within 12 months of this local application you can file application abroad. So you get 12 months to file application abroad. In direct route you are not getting any time. In direct route you have to file application on the same day, but through Paris Convention route you can file application abroad 12 months from local application filing date. Now through PCT route you file local application in your home country. Maybe you can file the priority provisional application first, and within 12 months of provisional application you can file PCT complete application. That too you can file again in your home country. So in PC2, after filing initial application in your home country, you get 30 months to file application abroad. So you get 30 months to decide whether you want to file application abroad or not. If you want to file, then you can file application abroad within 30 months. There are additional benefits of PCT. If you see this slide, you can see at 16 months from priority date or local application filing date, the patentee will get international search report and written opinion on patentability. The WIPO, World Intellectual Property Organization International Bureau, the WIPO office, they conduct the search related to your application and they provide written opinion on patentability. So at 16 month, patentee or applicant will get this report on search and on written opinion on patentability. So based on that report, he can find out whether his invention is patentable or not patentable. So based on that, he can decide whether he want to file application abroad or not. At 18 months, the application will be published. 18 months from priority or earliest application, the application will be published. It will be open to public. Additional benefit provided by PCT application is at 22 months. At 22 months from priority or earliest filing application date, patentee or applicant can request for supplementary international report, and he can also request for international preliminary examination. So he can request for both, for search report, international search report, and preliminary examination report. This he can do at month 22. But both of these are optional, they are not compulsory. If patentee want to file for these requests, he can file. Otherwise, okay, these are optional. But these all requests, they are associated with the cost. You have to file the fees for international search report, and you have to file fee also for the international preliminary examination report. So all these requests are associated with the cost. Now patentee can decide whether he wants these reports or he can do without these reports. So at 22 months he can file the request, and at 28 months he will get these reports. At 22 months he has to file the request, and in next 6 months he will get this international search report as well as international preliminary examination report on patentability. Now at 28 months he has both the search report as well as examination reports. So based on these report, he can find out what are the chances of getting patent on his invention. Now he can decide whether he want to file application abroad or not. Now if he decide that he is having good chance for getting patent, then within next 2 months, from 28 months, he can file application abroad. So when you file application abroad, these are associated with the costs, certain costs like translation cost. When you file application abroad, you have to translate your application in the local language of that country. So that is associated with the cost. Then again you will incur the filing fee, local filing fee, and you have to file your application through local agent. You cannot directly file application abroad. You cannot directly file it. You have to go through the local agents in those countries. So all these are associated with the costs. So all these costs will happen in at 12 month in case of Paris route and at 30 month in case of PCT route. Now the grant of patent is country specific. Each country patent office grants patent for that country only. US patent is granted by USPTO. Indian patent is granted by Indian Patent Office. But there are certain regional patent offices like EPO, European Patent Office, which provides a common platform for grant of patent application across designated states in Europe. Means instead of filing patent application in each European country, you can file only one application at EPO, European Patent Office, and you can that application you can select in which countries you want, in which European country you want the patent. So you have to select those countries. So they will be called designated state or designated countries in Europe in that application. If you select all the European country, then EPO will grant patent for all European countries. If you select only 10 European countries, then EPO will grant patent only for those 10 European countries. So EPO is a regional patent office which provides a common platform for granting patent for European countries. So there will be one European patent for all designated or selected states in Europe that will be valid on all those selected states. PCT is only an application based on which national phase application can be filed in different countries. WIPO or World Intellectual Property Organization, they never grant any patent. They only facilitate the filing of patent application internationally in all countries. And patent based on PCT application will be granted by patent office of each country. That's all in this presentation. Thank you very much.